Hello everyone, welcome to What's Missing. Today we'll be talking about New York Bill A416, which was presented by Democratic Assemblyman Nick Perry, basically as a way to help enforce public health regulations in the midst of a severe health crisis like we are currently experiencing with COVID-19. Now, the reason I'm making this video is it seems like a lot of people are reacting really critically to this bill. Congressman Lee Zeldin of New York's 1st District, he's a Republican, was mentioning how this bill is ultimately unnecessary and a threat to people's freedoms and liberties. I kind of figured that, okay, I'll go through the bill and I'll try to break it down into a way that's at least easier to understand. Alright, so subdivision 4 of this bill says that confirmed cases and possible cases that were detained as a result of being a public health risk will no longer be detained after they are determined to no longer be contagious or after they've been determined to not be carrying the disease or the illness, and in the case of radioactivity, like not carry any radioactive poisoning on them. Subdivision 5 states that any infection or medical condition will be treated and assessed on a regular basis, and the detainee will be held in a manner consistent with isolation and infection control principles. So that basically means, when they're detaining people as a public health risk, they are kind of acknowledging that somebody who might or might not be infected, like I was saying earlier, there will still be protections inside of this supposed detention area where positive cases and people who might be positive but might not, everyone will be separated in such a way that they will not pose a risk to each other. And that's kind of what those isolation and infection control principles are meant to do. There's always some risk. I mean, even the COVID regulations in New York and any state, they're not perfect. People are still getting sick even if they try their best not to. Even if they're wearing a mask every day, there's only the best you can do. As for infection or medical conditions will be treated and assessed on a regular basis, this is basically how they will determine A, if your symptoms are improving, if you're getting better from the infection, B, if they need to try some other type of medical treatment, and C, it'll be kind of that moment where they ask it says assessed here, assessed on a regular basis. So they will be testing you on a regular basis. And granted, that is vague language, but having the words regular basis inside of that bill kind of demands that when they're doing their testing, they can't test you once every month or once every 3 months. They have to do it more consistently than that. I mean, it's right there in the text. They can't deny that. Otherwise, people who were detained and not tested for 3 months could go back to court and say, hey, they're breaking the laws in this bill. And the governor and their delegates could be, punished in some way as a result of that. So at this point, you kind of get the idea that, people are being detained because they have a disease and maybe they're not following public health regulations. And the fact that they're not following public health regulations is the main thing. They're not just detaining anybody that has COVID or somebody that decides not to wear a mask once when they go inside of a Walmart. There are regulations that keep you accounted. And there are some fishy parts in here, but we'll get to that later. Right now, I'd like to start with subdivisions 7 and 8. This basically just says, if the order applies to a group, it may be posted in a conspicuous place on the detention premises, and if it is just an individual, the order will be provided to that individual. The order will include the purpose for detention, the legal authority under which the order was issued, and the sections of this law relating to their detainment. The detention order will also include a description of the circumstances and or behavior resulting in a person or group's detainment, kind of illustrating why you're there at all. It will also outline the less restrictive alternatives that were attempted and were unsuccessful and or rejected, and the reasons those alternatives were rejected. The detention order shall inform a detained person that they may request release or request legal counsel, basically making sure that you have access to some kind of recourse in the event that you think you shouldn't be there. And it also says that all detained persons have the option to provide addresses and phone numbers for friends and relatives that the department will inform of the person's detention. And I think that's kind of a smart thing to include. because it does kind of make all-inclusive this idea that, okay, everybody's going to be able to have their family know where they are. This next part basically concerns, let's say you receive a detention order and you are kept within those detention premises for more than 3 business days. Basically, these are rules for the governor to follow, basically stating that the governor shall get a court order within 60 days of your detention or within 5 days of a detained person's request for release. So I guess this kind of puts the detained person in a situation where they better request release after 3 days. Otherwise, they could be stuck there for a couple months, and if the court ends up saying, no, we don't want to give you a court order, and thus you get released, you were probably kept there for a couple months for no good reason. And that would kind of suck. This bill also kind of specifies that, interpreters will be provided to the best of New York State's ability. Kind of the difficulty in that, however, is if you can't get an interpreter for a couple weeks, that won't be, you can request release on the 4th day and be released by that next week or the next 5 business days. But you will be stuck in a situation where, you had to wait 2 weeks instead of those first 4 days to request release, again, because that resource isn't directly available. And that to me is kind of messed up, but that is a matter of a lack of resources as opposed to overt corruption. A court order within 60 days of a person's detention or within 5 days of a detained person's request for release. There must also be a court review within 90 days of a completed court order, and then another court review within 90 days of the last one. So basically that would be like the 3-month or within 3-month checkup that the courts would be able to do on how your case is going, when you'd be able to be released. In the event of COVID-19, I can't see being kept for more than a couple weeks being necessary. And again, there is kind of this issue of okay, they will be testing you to see when you test negative and then they'll let you go. So that's great. But I think this is more meant to include things like, let's say you get radioactive poisoning. And I'm not sure how long that poisoning lasts, but it's definitely not 2 weeks. I mean, I've heard cases where multiple years after people are poisoned by radioactivity, they end up dying from cancer and the like. So I kind of agree with that. It does seem like a long time for something like COVID, but again, this isn't just about COVID or an infectious disease. It's about chemical poisoning, radioactive poisoning, any serious public health threat. Okay, and this next part is kind of important. The removal or detention of a person or group, or the review of someone's continued detention, again by court review, can only be issued after the governor or his/her delegee presents clear and convincing evidence that the individual is a public health threat. So basically what that tells me is that a governor just can't detain anybody they want to. They have to get a court order, and courts are very, very picky, especially when it comes to evidence. It just can't be, he didn't wear a mask in a Walmart one time. It has to be consistent, provable behavior with at least some kind of information, some type of evidence to support that fact. So, at least in that case, a detained individual is protected by the weight of evidence that a governor has to provide. So, while I agree that this is a good way to prevent the governor from abusing this system, the next part of the law, subdivision 12, is where this whole situation kind of gets a little tricky. In addition to removal or detention orders, the governor or his/her delegee may seek enforcement of any other orders that he or she determines are necessary to prevent the transmission of contagious disease threatening the public health. Okay. This includes demanding people or a group be isolated in their home or sufficient premises of their choice. It requires testing and examination of anyone infected or exposed to a disease or toxic radioactive material like we talked about. Anyone exposed to or infected by a contagious disease must complete an approved treatment regimen. And it does say later on in this bill that basically you can't force somebody to take medication without a court order, so that does add another degree of protection for the detained individual. Last but not least, basically detained persons or a group of detained persons, they will have an opportunity to be heard upon request, but subdivisions 2 through 11, which I already kind of walked through a moment ago with you, those subdivisions will not apply to these other orders that a governor might insist they have to provide or issue. And to me, that's kind of weird. This is kind of a situation where it's like, okay, you went to all this trouble outlining in this document that you're going to painstakingly, you're gonna provide legal counsel upon request. You are going to allow somebody to contact their family by providing phone numbers to the detention center, to the department in question responsible for that center. And then you just go off and say, oh yeah, subdivision 12, yeah, you'll have the opportunity to be heard, but the previous parts that we just talked about intended to defend a detained person, yeah, that doesn't apply to these other possible orders. And so then that makes me ask the question, like, okay, what are these other orders? If it's not a detention order, if it's not a court order, then what other orders are we talking about where potentially the governor could just circumvent all those rules you just established to protect people? Like, that seems a little gray to me. Like, that's a little fishy. And it's not like I think the state of New York is like openly planning to like detain everyone and anyone on these other orders that could possibly be issued. But it is kind of a situation where like it's a little too gray, this bill needs to be revised to be a little more specific. Now, I did a little research on the Legal Information Institute webpage from Cornell University, which has some information on what tenets are used to examine legality of any specific set of court procedures. One of them is determining the private interest at risk in a given case. Let's say you're in a case about whether or not your social relief should have been terminated. The private interest in that situation would be getting your social relief back. In this case, the private interest would be whether or not the individual gets detained, and then everything associated with that, so like, okay, you get detained and you could be stuck there for a month or 2 weeks. That could be enough time to lose some of your income or lose your job entirely. I mean, if you're not paying rent for a month or 2 months, I mean, you could potentially lose your apartment, and that could be a situation that is very damaging for people, especially if you have kids. I mean, that would also be included in terms of that risk taken, if you get detained. The second part of this is the risk of erroneous deprivation of private interest, meaning how likely it is that a given procedure might unjustly result in someone losing their social relief, or in our case, unjustly ending up detained because of this new bill. The final tenet is the government's interest, the function being served by the state, but also how much it costs to facilitate the procedures intended to prevent that function from being tyrannical. So, I'm no lawyer, I'm not a judge, but we can reasonably guesstimate how this bill measures up with those tenets I just described. For one, the impact on private interest in this case seems to be relatively medium in the middle. It's not a 10 to 25 year sentence like would be the case for something like first-degree murder, and it's not on the lower end of, say, being charged with community service for vandalizing a school gym. In my opinion, this bill is very loose in terms of the fact that it could be referring to days of detention, weeks, or months. And granted, that time frame, like I already said, could result in some problems in terms of how that detainment could affect your life, your family, and, that's something that should be taken into consideration. Now, the risk of erroneous deprivation of private interest in this case does seem to be in the middle as well. I mean, let's say the governor fails to provide sufficient evidence proving someone is a public health risk, and the judge ends up approving a court order anyway, which again is a relatively mild injustice compared to being falsely imprisoned for murder and receiving the death penalty. It's weird that this bill doesn't seem to require that the detained individual have the opportunity to provide counter evidence to defend themselves from a court order. Even if an individual can request legal counsel, it doesn't say that the individual can defend themselves in court against that court order directly. To me, that's a significant flaw. The ability to provide counter evidence is a huge part of what we typically describe as acceptable due process. I think we can all agree that the possibility of injustice should always be kept as low as possible. It's also important to consider that, again, Subdivision 12, allowing the governor to file other court orders other than a detention or court order, like without having to abide by these other rules like we talked about. I mean, that's kind of weird too, kind of a risky part of this bill, and should definitely be revised. All right, and now we're on to the third tenet of, what kind of defines due procedure, which again defines government interest, which would concern this bill as a whole. The ability to detain persons without an arrest warrant in the name of protecting public health, which to me seems to be, like government interest in this case seems to be pretty high. It will depend on the disease, of course, the lethality of it and how contagious it is, but in terms of containing a pandemic of any kind, this bill could be considered critical in terms of preserving the economic and civil well-being of any state, since the governor's office would have to acquire evidence concerning every detained individual, likely working in concert with local county health departments, creating a whole new set of costs and likely taking up hundreds of work hours. So the cost of this bill is already really high. I can see the government being kind of uninterested in, acquiring more costs in the name of defending an individual's rights and liberties, even though in our case we can kind of see how this bill has some flaws in that regard. That additional cost might be necessary. So while there are aspects of this bill that make a lot of sense to me, there are parts that are very questionable, like subdivision 12, and there does seem to be a lack of opportunity for a detainee to defend themselves in court, which again is to me anyways, a big issue if we're talking about due process. But anyway, that'll be the video for today. Please let me know what you think in the comments below. Please like the video if you enjoyed this and subscribe for more political content. Hit that bell if you want to be notified upon my next video's release. Take care and have a great day. This is What's Missing.